Good morning, everybody. Thank you so very much for being here. I am extremely excited about the journey that we are getting ready to embark upon as it relates to our children. This is an issue that is extremely important to me, and I know to many of you as well, because you are here to represent our children. And so with that said, I would like to thank the staff for your work and helping us getting this SR together and ensuring that we at least have the four corners of the aspect of the issues that we are extremely concerned about. And do we have a roll?
Yes,
Okay, all right, thank you. If you would call the roll, please.
Okay. Senator Barrow.
Present.
Present. Ms. Russell.
Present.
Present. Ms. Hadley.
Present.
Present. Dr. Germain. Mr. Thurber. Present. Judge Guillory. Judge Green. Dr. Hook.
Present.
Present. Ms. Brocksmith.
Present.
Present. Ms. Wascom.
Present.
Present. Captain Songji. Present. Ms. Shelton.
Present.
Present. We have 9 present.
Okay, and we also have Mr. LeVar Robertson, representing Fathers on a Mission.
Present.
And so what I would like to do really quickly is talk about the resolution and what really brought us to this point. And Judge Ritchie is in the audience, and she's going to come to the table and talk about some of the work that she and I have been working on it and some of the things that we are doing. But the first paragraph of the resolution really, to me, really explains the importance of this work. When we look at the findings from the Director of Crimes Against Children Research at the University of New Hampshire, and he states the impact of child sexual abuse is profound and long-lasting, affecting not only the victims, but also their families and their community. Early and effective intervention is crucial to mitigating these effects to bring justice to the victims. And my whole thrust, and one of the things I have really been a huge advocate on, is ensuring that we protect our children. And one of the things that I learned, and which is what led me to create the Office of the Ombudsman, is how there are many gaps in the system, and how, unfortunately, we had too many kids falling through the cracks. And so was very excited to create the Office of the Ombudsman with the support of many of my colleagues and getting that bill through the process and having it funded. But then there became another issue that I had a question. Someone called me about a situation with a sexual abuse situation where the abuser was still able to get the child, and I asked her, how did this happen, and why is it happening? And she said, there are many aspects to this. It's not easy to figure out. It's very complex, and that this is something that we really need to take a look at, and that's how this SR came about, because way too often, and I'm going to ask you, Judge, if you would come to the table, because you can start talking about the ombudsman program, the conversation that you and I had, the complexities around this matter. And we don't want to, as the legislative branch of government, do not want to infringe upon the judicial branch of government, but certainly there are many aspects that we don't understand. And when it comes to the safety of our children, we need to ensure that we are kind of getting on the same page in eliminating barriers, gaps, anything that puts our children at risk. And so with that, Judge, I'm going to hand it over to you. You could talk about the Ombudsman's program, which you're doing currently now. and also our conversation. But you know what I think I need to do really quickly is have everybody quickly introduce themselves so you'll know who's all up here and who you're talking to. Some of the individuals you may already know, but we want to make sure that everybody in the room knows each other and their background and the perspective of which they bring to the table. So I'm going to start to my right with, is it Dr. St. Germain? No? Ms. Shelton? Yes. Okay.
Michelle Shelton.
Hold on, how do you press the button? Okay, there we go.
Michelle Shelton. I'm the Deputy Director at the Louisiana Child Ombudsman's Office.
Yes. Mr. Robertson?
Hey, LeVar Robinson, founder, executive director of Fathers on a Mission.
Ms. Hadley?
I'm the director of forensic interviewing at one of our children's advocacy centers in Shreveport, Louisiana.
Okay, great. Ms. Brocksmith?
Good morning.
Can you speak directly to the mic?
Sorry. With the Department of Children and Family Services, and I'm the Human Trafficking Services Manager.
Say, introduce yourself one more time. Pull it down.
I'm Lauren Brocksmith. I'm with the Department of Children and Family Services, and I am the Human Trafficking Services Manager.
Thank you. Ms. Hook?
I'm Dr. Rebecca Hook. I am the medical director for child welfare and also now the interim assistant secretary for child welfare.
Okay, great, thank you. Ms. Russell?
I'm the District Attorney of Lafourche Parish, also the President of the District Attorneys Association and the Director of the Children's Advocacy Center of Lafourche.
Thank you. Mr. Sanjay, I'm sorry.
Ma'am. My name's Mike Sanji. I work for the Ascension Parish Sheriff's Office. I'm a captain over the juvenile unit, and I'm over school security and juvenile abuse.
I thought I recognized you. Mr. Thurberg?
Thurber, yes.
Thurberg, okay.
So I'm the appointee of the Louisiana Psychological Association. I'm a professor at the LSU Health Sciences Center in forensic psychiatry. I do research on child development that has relevance to sexual abuse investigations.
Thank you very much needed. Ms. Wascom.
My name is Audrey Wascom. I am the STAR appointee. I've worked in this field on and off for 25 years, but I'm also a survivor of child sexual abuse, child sex trafficking, and CSAM.
Okay, thank you. So I want to thank each of you for being here. Thank you for agreeing to serve on the task force, and thank you for helping us come up with solutions to bridge the gap and to address some of the chronic issues that we face in this arena, unfortunately. Okay, so with that, Judge, we're going to now turn the baton over to you.
Is my microphone on?
Yes.
I'm Kathleen Stewart Ritchie, and I am the State Child Ombudsman. Michelle Shelton is the Deputy Child Ombudsman and the designee, our office designee for this task force. I don't know how many of you know very much about the Ombudsman. It is a new office. It is within the Office of the Legislative Auditor. Created by statute in 2023. The office began 1 year and 3 weeks ago. October of 2023 was when I came on board, and Michelle came on board July of 2024. So it's fairly new. Under the statute, there are two bodies of work for the State Child Ombudsman. One is systemic, to look at issues that affect children and families in the state, and to make a systemic evaluation as well as recommendations for improvement for services to children. There are several duties under the statute, one of which is, for instance, reporting to the legislature on conditions of confinement for children. It runs the gamut. Any service provided to children using public funds is our jurisdiction. So you can imagine how broad that is. The second part of the legislation, in the way I view it, is an individual service. We receive and investigate complaints and mediate on behalf of the child and family with the department who is to provide services. So we have been in existence now for a year and 3 weeks. And I think that that the way that this all began was a constituent of Senator Barrow's called her, and then she called me to see if there was some way that, something I could recommend. The constituent had already talked to me, and when I pointed out to Senator Barrow that this was not the only complaint regarding the investigation and outcome of a child sexual abuse allegation, the task force arose because Senator Barrow was really keenly interested in what legal modifications needed to be made to protect children. And I pointed out that there are a lot of moving parts in a child sexual abuse investigation, and that you can't just you can't flip a switch and have everything fixed. That the impacts are significant. No matter what the outcome is, the impacts are significant. And I will point out that I spent 11 years as a public defender. I represented people who were falsely accused, as well as people who were rightly accused of child sexual abuse. I had a client one time whose 11-year-old stepdaughter accused him of sexual abuse, and he was charged with indecent behavior with a juvenile. We had selected the jury when the child recanted and told the assistant district attorney that she made it up because she wanted her mother to leave her stepfather and get back with her father. So she, along with some friends, had come up with this elaborate scheme, and this man's world was destroyed by a false allegation. So it is important to recognize that allegations can be false. I would submit that the child needed help anyway. That's a huge complaint to make when it's not true. But on the other hand, there are children who, because of their age, are not very articulate, and a 3-year-old talks like a 3-year-old. That doesn't mean that she isn't being abused. So there is a need to consider the impact of the investigation and the processes involved in that. And it needs to consider everybody's point of view. So that's why the task force has representatives from each of the entities that are involved and each of the entities that are impacted. And it was with that hope that we'll be able to come up with some solutions if we can identify patterns. The complaints that we've received in this year and 3 weeks are almost 250. I wish I could give you an exact number, but we're in the process of developing and uploading into a database the complaint process that we've encountered so far. More than 10% of our complaints are regarding child sexual abuse investigations. Now, that breaks it down into some very specific allegations or complaints that we've received. So we've seen some patterns, and I'm here to point those out just as a jumping off point for the work that this task force will do. I do want to start with centralized intake because that's the first place that a report for child sexual abuse occurs. And in our in preparing to identify the issues that have been presented to my office, we did talk with centralized intake and are working with them to understand the process of centralized intake. And one of the things that we discovered was that there is no specific protocol for interviewing a report on child sexual abuse. Although centralized intake has a protocol for a child fatality, and they have a protocol for drug-exposed newborns, and a protocol for trafficking, there is no specific protocol for the extent of the interview for a report of child sexual abuse. There's also, we discovered, no training specific to child sexual abuse for an interviewer, and we are working with the department to identify appropriate training. And I know the CACs provide training, and the training that the forensic interviewers go through is available to both law enforcement and DCFS, but we're told that they often don't participate. So we would need to curtail or develop a training that is accessible for DCFS and targeted to the interviewing process that centralized intake undergoes.
Judge, before you go any further, I have a question, but if anybody have a question while she's speaking,
You can
please
interrupt
just
me.
press your button and I will recognize you so that you can ask your question. When you said the department, which department were you referring to?
DCFS.
So they are responsible at this point for all training?
Well, DCFS has a plethora of training. They have a lot of training, and I know from my work with CASA that the trainings are excellent trainings. There's just not a specific training when you're doing an interview of a child sexual abuse report.
Okay.
So, and DCFS, I mean, the CACs, for any of the accredited CACs, we have, I think it's 16, maybe 15 CACs.
How many?
In the
15.
in the state, and I think 9. I'm pulling from my memory from years ago. 9 that are accredited through NCA, National Children's Alliance, and there are some standards for training that are implemented or required through NCA to maintain accreditation. So the CACs have a very robust interviewing training. And I think that partnering with the CACs for that training might be very efficient and effective for identifying an appropriate training and developing an appropriate protocol for those initial reports. Now, when a report comes in, DCFS, the data unit, was able to give me the numbers of investigations of child sexual abuse, but they weren't able to tell me how many reports of child sexual abuse there had been. The report has to rise to a certain level to initiate an investigation. And every year, it's like maybe 48% of the reports of child abuse and neglect are not investigated. The information provided does not reach the level that DCFS has determined to initiate an investigation. I don't know how many of those 48% are reports of child sexual abuse.
Okay, we have a question, Judge.
Yeah.
Ms. Hadley?
Yes, I'm the director of forensic interviewing. And what is your, I guess, reason or ideation of wanting DCFS and law enforcement to be trained to interview when that's what the CACs do for them in their investigations?
I'm talking about centralized intake. When a report comes in, what questions is the report taker asking to determine if there's even a basis for an investigation? I'm not talking about, I support CACs doing
I
interviews
understand
for
that.
all
I just wanted to get
child
clarification.
sex
Yes,
abuse victims. I'm specifically referring to the intake process. We have met with an intake interviewer, an intake worker in DCFS, and in the course of that interview, we just did some play acting, and I said, okay, I'm grandma, and I'm worried that somebody's messing with my grandchild. And, what do you ask me? And there was a lot that I could have told them if they'd only asked, but they didn't ask. So I'm thinking that, and that was just play acting. I'm not suggesting that the on-the-job interview report, intake person doesn't ask more questions. But I'm concerned that we maybe some cases may not rise to the level of investigation simply because we don't ask the right questions. So I think that if we can train the intake staff specifically in questioning reporters of child sexual abuse, we'd have a better idea of what cases should be investigated and which ones shouldn't be investigated.
Yes, ma'am. Thank you.
And also, let me highlight that if you look at DCFS data, the number of children with cases for child sexual abuse is not the majority of the children in the state. The majority of the children in foster care are children who have been neglected. And then physical abuse is even higher than child sexual abuse. But the impact of child sexual abuse is significant, and that's what we're focused on in this task force. So my comments about training people for interviewing is for that initial report. Okay.
And thank you for that analogy, because I was going to ask you, so that was a good example that you gave in terms of what that would look like and what is not actually happening perhaps now because of the lack of training.
Right. And the concern I have, again, is that if the interviewer is asking, you have different levels of interview, and if you call in and get an interviewer who's very thorough, that might rise to a level of investigation. If you call in and someone is not as thorough, then that case may not rise to the level of a full investigation. And one of the other things is sort of an aside, but one of the questions that we asked was whether or not the centralized intake staff have access to secondary trauma training. Because as Michelle pointed out to me, and she's done a lot of this work, vicarious trauma and secondary trauma leads to burnout. And sometimes people can go on autopilot without realizing that they have. And then the quality of their interviewing is going to be diminished. So I think that's an issue that we haven't really talked much with DCFS about, but I know they'd be open to that. I think that the work that the DCFS staff perform is arduous and emotionally and physically draining, and I think that's why they have such staff turnover is just burnout. And we ought to be able to come up with a way to support the staff and keep the staff that is doing good work from burning out. So that's just an aside. It's not necessarily focused on this particular issue. After centralized intake, if the information rises to the level of an investigation as determined by DCFS, then there are questions that have arisen based upon the cases that we've seen. One is like what is the protocol for investigation? I've had a reporter who was a therapist, a provider, complained that she had reported child sexual abuse, and then she got a letter that the investigation was invalid, and no one had talked to her. So I don't know what the requirements are, what all steps have to be taken in an investigation, but I think that might be something to look at. Reporters.
So I don't want to assume, but it sounds like all of this happens under the direction of the Department of Children and Family Services.
Right now I'm talking about the investigation by DCFS.
Okay.
But law enforcement is involved and CACs are involved, and it is unclear to me when law enforcement is called in.
Okay.
Some of the complaints we've received have involved law enforcement and some have not. Some have had CAC interviews, some have had multiple CAC interviews, and some children have not. Mm-hmm. Sometimes DCFS has access to the CAC, the taped forensic interview, and sometimes they do not. So it's not consistent across the board, is I guess what I'm saying. And I think maybe a protocol that would be consistently utilized would give us a more effective response to child sexual abuse.
So do you know who determines when law enforcement is called?
I would assume it's DCFS.
Okay. Can you, Ms. Brocksmith, would that be? No. So is that Ms. Hook? Okay, Ms. Hook.
It's Dr. Hook.
Dr. Hook, yes. Change that, please.
And so anytime that there's any possible criminal allegation.
Speak into your mic, please.
Sorry. Anytime that there's any criminal allegations that are made, then a referral to law enforcement should be made by the agency if one has not already been made by the mandatory reporter. So, for example, if a healthcare provider is the mandatory reporter, often that law enforcement referral has already been made, and it is important for us as an agency and for law enforcement as an agency to work together to be able to make sure that those appropriate reports are made to both agencies.
Well, and one of the things that I am consistently explaining to the complainants is that law enforcement has a different standard of evidence. Arrests will not be made unless there is reason to believe that the state can prove beyond a reasonable doubt that a crime occurred. And so sometimes law enforcement is involved and do not take any action because the evidence would not support a prosecution. The district attorneys are sometimes involved in those investigations and sometimes not. District attorneys have authority to charge a person criminally if they have the evidence that would support a conviction, and that would be proof beyond a reasonable doubt of a specific crime. But the district attorney also has authority to file a child in need of care pleading, a petition, even if DCFS doesn't request it. So I'm not sure that that has ever occurred. I know district attorneys' offices are overburdened as well. I do know that at least one complainant that I had contact with had an interview with the district attorney's office because the law enforcement did not find sufficient evidence for a crime, and DCFS had invalidated the report, and she felt strongly that there should be some action to protect the child, and had conferred with the district attorney to determine if the district attorney could file a petition, even though DCFS had not requested it. By law, they can. I just don't think that's the typical practice, and Ms. Russell would probably be able to address that, or could find out from district attorneys around the state.
Ms. Russell, would you like to speak to that?
I have filed when I have read, and even though it's found invalid by DCFS, I have filed child needed care petitions. I can't speak for the other 41 district attorneys, but I absolutely have done it. And part of that, what has helped with advocacy centers is prosecutors attend MDT staffings. And so if everyone's at the table.
Would you tell me what
Sure.
MDT stands?
Multidisciplinary team meetings are held by advocacy centers where representatives from DCFS, law enforcement, the district attorney's office, and they meet monthly. And the purpose of the team meeting is not about prosecution or anything. It's really to make sure the child's receiving the services the child needs. However, at the same time, we can make sure that we have the information that we need for our case, as well as DCFS, making sure they have the information for their case, and law enforcement as well. And it forces communication, because the number one issue that we're talking about right now is lack of communication between agencies. And so MDT meetings force communication, and in the end result, everybody has better cases.
Okay.
And
Hold on, Ms. Hadley?
I do want to add to that with the multidisciplinary team meetings. The hope and goal is that it's always prosecution-led, because eventually this is going to be potentially their cases in the courtroom. And the goal is to keep everyone accountable, to make sure that children are not falling between the cracks, and that we can work alongside each other, knowing when to pass that baton, because not every agency or service can provide everything for the families. And so we all need to know that. We all need to come collectively. And then as far as reporting goes, at our CAC in Shreveport, we try to do our due diligence by training our communities. So we do a lot of education and prevention on our end. We go into the schools, we go to the hospitals, we go to the pediatrician's office, wherever they work with children, even counseling offices, and we educate them on proper mandated reporter training. A lot of what we like to do, just to kind of blanket it all, whenever it comes to physical or sexual abuse concerns in the community, we educate our community to report both to DCFS and law enforcement, and we educate them on the differences of their investigations. DCFS being welfare, law enforcement being more of the criminal side, and that they work alongside together to help serve the child and the family. So
Yeah.
we try to help in educating our community. As far as all CACs, I can't speak for all of them. We all run differently just based on our jurisdictions and the capacities that we have within our own CACs. But the hope and goal is that we can try to educate more in our community to make proper mandated reports.
Right, and I think I'm a dinosaur, so I predate CACs. And one of the issues that the CACs were developed to address was the nature of the interview of a child, that children require a different level of sensitivity in terms of disclosing what's happened to them. And the idea was that the CAC would be a child-sensitive interview that was recorded, and therefore the child wasn't subject to multiple interviews.
Yeah.
We have seen cases where children are nevertheless subject to multiple interviews. And I think that is something that we ought to address as well. I'm not suggesting that there's anybody doing anything wrong. I'm just suggesting that there are a lot of holes in this process as it has sort of adjunctly developed across the state.
Hold on, we have two more questions. We have two more questions. Ms. Wascom? No.
I have a question, but I'm not sure if it's directed to you or to DCFS. It's sort of a two-prong. Is central intake fully staffed? And do they all have like the same, do they all come with the same qualifications and training in the centralized intake if they're taking the initial report?
So I think that's a question for Dr. Hook.
I think it's for Dr. Hook.
So centralized intake workers do have to undergo a set training or curriculum in order to enter the role. We are not fully staffed. Our staffing has improved, but we do have vacancies within centralized intake. So we could use some additional positions, and we are trying to adjust our workflow and our scheduling in order to best, meet the needs for centralized intake. As far as qualifications, they do go through an interview process, and I wouldn't be able to speak on the bare minimum qualifications that are required, but there is a standard training.
So follow up to that question, Dr. Hook, the issues that y'all have as it relates to staffing, is it because, is it related to just lack of budgetary issues in terms of being able to hire more people, or is it because y'all just cannot find the qualified people to actually fulfill the positions?
It is a combination of both currently. Okay. So we do really require more TOs. We need more positions within the agency for sure. But also, as Ombudsman Ritchie has pointed out, there is some burnout. There's turnover that can occur. Centralized intake, we have done pretty well in maintaining the people that we have in the workforce. But also sometimes people get promoted within the agency and leave, and that will create another vacancy because a lot of the people that we have working in CI or centralized intake are very strong workers and competent workers, so we do lose some people for those reasons as well.
Okay, thank you. Okay. All right, you may proceed.
I had raised the concern about best practices in interviewing, and my observation is that CAC interviews are much more effective in court for a court process than those children who are interviewed in the backseat of a squad car or even by a DCFS investigator. So to ensure that the process involves a CAC interview for a child, I think is critical. There are specific statutes governing CACs in the Children's Code. One of the issues that has arisen is what happens with the tape. There was one case where the grandparents had contacted my office. DCFS had investigated and invalidated a complaint regarding child sexual abuse of a 7-year-old. The grandparents had filed a protective order in civil custody court. It wasn't going well, and the grandparents were very upset, but requested through their lawyer that the judge have an in-camera inspection of the CAC forensic tape, which she did, and that is rare. But this particular judge reviewed the forensic tape interview of the child and granted the protective order. The parents only see this child now with supervision because the CAC tape was that compelling. But that doesn't happen often. So the admissibility of CAC interviews and the way to maintain the privacy of the child and the family with the interview is something that probably should be addressed by law. One of the issues that I have come across, too, that I wanted to raise is cross-jurisdictional issues. We've had a couple of cases where when people move to another state, there's problems. We have one case where the allegations of sexual abuse occurred in Texas, and so Louisiana doesn't have any authority to do anything. And I don't know that the state law can address that. But there is another case where the grandmother had reported mom's boyfriend the child disclosed that mom's boyfriend was sexually abusing her, and she reported, and law enforcement was involved and DCFS, and so the family moved to Mississippi, which meant then that the law enforcement couldn't do anything, and Mississippi they referred it to Mississippi law enforcement. DCFS referred it to Mississippi Corollary Department of Social Services, and they couldn't do anything because the allegations of child sexual abuse had occurred in Louisiana. So the case was closed because the people were living in another state, and 8 months later they moved back, but the case was closed. So, and there had been no new allegations. So we maybe need to consider policies or protocols that would address those situations. I mean, it's pretty easy, depending upon where you live, to move across the state line and let the heat cool off and move back, and that's what happened in that particular case. I think that it's important to identify best practices in terms of the interviewing of the child and the use of those interviews, and multiple interviews of children can be a significant concern. I'm also concerned about parish to parish, because even if families don't move across state lines, they move from one parish to another, and that has created some issues. There was one case where when mom and dad split, mom and the children moved to a parish away from the family home, and the child, who was very young, 3 years old, behavior was strange, and so mom got the child into therapy. The therapist made a mandated report, and DCFS, in the course of its investigation, was concerned enough that they filed in the course of the investigation, filed a petition for an instanter safety plan. The juvenile court heard the case over 3 days and issued a safety plan for this child, giving father visitation but supervised visitation, and then transferred the case to the parish of the family home. The juvenile judge in that parish declined jurisdiction and transferred it to the court that was handling the custody matter. The department's findings were inconclusive, and the custody judge said, well, nothing happened then, or there's no evidence that anything happened. And so that changing of jurisdiction is an issue that I think needs to be addressed, and the judges involved can address that. I also think that the department's findings may have an outsized influence in custody court. When there is a valid the law outlines what constitutes valid, invalid, and inconclusive. An invalid finding doesn't mean that nothing happened. It means that there wasn't evidence to support the finding. But I'm not sure that that's how it is being construed. In civil court that's not familiar with the juvenile jurisdiction and the Title VI of the Children's Code, one of the issues regarding the filing of a SINK case, the reason that this woman asked for the SINK case was that clearly the evidence wasn't going to support a criminal prosecution, and DCFS had found the allegations to be invalid, but the district attorney did proceed with the case. So sometimes the standards that the department operates on are different than the legal standards. And the law is very nebulous, and it talks in terms of evidence to support the allegation as opposed to true or false. An invalid finding doesn't mean that the allegation is false. It just means that there isn't evidence to support it. And when you have a very young child, that's often going to be the case. Very rarely. And I actually argued this to a jury one time. Sexual activity doesn't happen with an audience, and so the truth of what happened is often who you believe. And children who are young and unable to express themselves fully are often not believed. And if
I know. This is very depressing. I'm trying to keep it together. We have two questions, Judge. Ms. Hadley?
Well, I was just going to say with the cross jurisdiction, this is not so much of a question, just more of a statement. We try to inform our law enforcement that the CACs network really closely together statewide. And so if a family does proceed to move out of state, even though the abuse may have occurred in Louisiana, we educate our law enforcement to know that we can connect them to the CAC that they in that area that they move to, where the child can still have an interview done at that local CAC wherever they move to, where they can still proceed in their investigation here in Louisiana.
Yeah, well, not in this role, but in another role that I was in.
Yes, ma'am.
I will observe that CACs are different. There are some CACs that are very effective and some CACs that are not as effective, particularly when you're crossing state lines, because the laws change. And so the CACs are focused on and operating under different principles than the CACs in Louisiana. And within Louisiana, the structures of the CACs are significantly different.
Right.
But I do know that that is an option. I don't see it being utilized very much.
Thank you. Mrs. Sanjay?
In Ascension, whenever we do cases with jurisdictions, whether it's parish to parish or state, we do, if it happened in my parish, I don't care if they moved to Texas or whatever, we're working that case. We do the CACs for Texas, for Mississippi as well, even if nothing happened in Louisiana.
Does your department have a written protocol to that effect and how you implement that?
I'd have to go back and look at that, but we just do that.
Yeah, I think that one of the concerns I have is that it really depends upon where you live as to what's going to happen.
Understand.
And that might be able to be addressed with written protocols that can be adopted and implemented across the state.
Yes, ma'am.
Because there are some places that are doing an excellent job and some places that are not. I don't think it's because they don't want to do a good job. I think they maybe would benefit from having guidance from those parts of the state that are functioning really well.
Yes, ma'am.
I mean, it was not Ascension Parish where the law enforcement dropped the ball. Just,
And I'd say we do
to
everything
clarify the record.
Yeah, we do them all. If it happened in my parish, and even when it gets to the social media stuff, because people bounce it. Where did this happen? Where did that happen? We just work it. Like I'm not playing games back and forth and all that stuff. So we just handle it. And I know a lot of parishes do the same thing, and I know some that don't. But our CAC does. If we call middle of the night, hey, we need an interview from Texas or this and that, if it's all possible, they're there and they do it.
Right. And it's important that children have consistency because the more people that get involved in these investigations, the less likely the child would be to have the security to continue a disclosure.
Thank you, Mrs. Sanjay, and thank you for that glimmer of hope. You and Ms. Hadley are definitely giving me some hope here because I'm concerned. In some of the areas that I've heard about, it doesn't seem like there's that level of consistency nor that urgency, maybe. I don't know.
Okay. So you want me to continue?
Yes, ma'am. You can continue.
One of the issues that was raised this past session regarding inconclusive findings by the department was addressed in an amendment to the code that requires a second-level review for any inconclusive finding. The department's policy is clear that should be avoided if at all possible because inconclusive doesn't activate protective procedures for children. I don't know, that only went into effect August 1st. I don't know if the department has had any experience in reviewing that second level internal review of an inconclusive finding. But the idea is it'll be another set of eyes uninvolved in the original investigation to determine if there's something else some other person that need to be interviewed or some other records to be reviewed before the final decision of inconclusive. One of the issues that has come up more than once with ombudsman from complainants with the ombudsman's office is reporters who complain that they didn't know what happened. They don't know if anybody even investigated the report that they made. And we have had complainants who are concerned that there was an investigation. They know there was an investigation, but they were never interviewed. One father even said, I have medical records that I don't know if they've even seen. So identifying the communication process through DCFS, and there are some constraints on what DCFS can say and cannot say. So within what DCFS is able to communicate, identifying that so that it's consistent across the state might be helpful for reporters. Regarding invalid findings generally result in court action through juvenile court. Invalid findings are the ones that we are hearing about. And the majority of these, there is a corollary custody case in civil court. So sometimes that is the problem. I have seen cases where DCFS concluded that the mother was coaching the child. In one case, the child disclosed to mom, who was a victim of domestic violence and had reported, and the investigation resulted in an invalid finding, and the civil custody judge found, based upon the invalid finding, that mom must be experiencing some mental health issues and remove the child from the custody of the mother and place the child in the custody of the father, and ordered the mother to undergo psychological evaluation. I read the psychological evaluation, and there was no finding of any kind of mental or behavioral health issue with the mom, but that child is in the custody of the father and can only have supervised visits with the mother. There was another case where, and again, this was a victim of domestic violence who, at a given point, moved. There was an allegation of unspecified physical abuse. Mom took the kids and moved and obtained a protective order against the father. DCFS was investigating the unspecified physical abuse when and determined that invalidated it because mom had a protective order. The notes in the file indicate that mom had obtained a protective order, permanent protective order, through the year 2025. And so when mom moved, she got the children into counseling, and the oldest daughter disclosed child sexual abuse. So DCFS is investigating the child sexual abuse allegation when the dad takes the invalid letter regarding the unspecified physical abuse to the court that issued the protective order, and it's now being dissolved. So there's a disconnect between civil court and juvenile court. The other case that I wanted to, when there is a valid finding, the individual against whom the finding is entered has the right under the law to appeal the department's finding. Those appeals go to the department, to the Division of Administration, the Department of Administrative Law, the administrative law judge. I'm trying not to talk in letters. I'm trying to spell it out. And the administrative law judge will then docket the appeal, and the administrative law folks are very focused on the fact that they're not saying whether something happened or not. The appeal is to determine if the department followed its policies. So the appeals are generally, I don't know. We haven't gotten the data on how many appeals reversed DCFS findings.
Judge, I must ask you this, and so at what point does, maybe just logic, maybe just kind of kick in? I mean, when does that happen? I'm just trying to understand. Can you help me?
Well, I hope everybody operates logically. I haven't always seen that, but
yeah, I'm not hearing it.
Well, I think, and let me emphasize that obviously the cases that are going to be calling the ombudsman are cases that didn't work, that at least somebody thinks didn't work. I hope and I believe that these are outliers, that the majority of the cases that are working their way through the system, children are protected.
Okay.
But I will. Let me close by talking about the case that started all this, the constituent that called Senator Barrow. In that case, there were two children. The parents were divorced and had shared custody. So the two children spent half the week with mom and half the week with dad. The 13-year-old little girl became depressed, and mom was concerned, took her to the hospital. The hospital admitted her through a physician's emergency certificate to be hospitalized. While she was hospitalized, she disclosed to her therapist that her father was sexually molesting her when he had custody of the child. The therapist, as a mandated reporter, called it in. The department investigated and validated the complaint for child sexual abuse. The father appealed the valid finding, and it was docketed with the Division of Administrative Law. The department then changed its finding from valid to invalid, which negated the appeal, and the civil custody judge threatened to hold mom in contempt if she didn't take the children back to the father for the shared custody. During the course of the investigation, this man's niece, a cousin of the child victim, disclosed that when she was a child, she had been sexually molested by the father as well. That child is still visiting or is in the man's custody 3 out of 7 days a week. And mom called not out of vindictiveness. A lot of our complainants want us to fire DCFS workers or OJJ workers. One of the oddities about the parents who called us is they just want to find protection for their children. They're not mad. Well, they're mad, but they're not seeking retribution from the department or from the court. They just want help protecting their children. And that's what this constituent of Senator Barrow's asked for. So that's what this task force is to do.
Thank you for doing such a great job of outlining everything that really kind of was
there's
the premise.
more, but I've
the
got plenty to
premise of the
start.
bill or the premise of this resolution. You gave a lot of recommendations. I haven't even counted them. And when I look at establishing scope and methodology, I don't even know where to begin. We have a tight timeline to actually come back with a recommendation, a proposal that I will submit to my colleagues and to the leadership of the legislature. And so with that said, I'm going to ask you to come back, Judge, and ask you if there would be 3 to 4 things that you would see of immediate change or concerns that we need to address. What would they be? And then I'm going to ask if the task force here would agree with those so that we can at least have a framework by which we would kind of start, because there's just no way. I mean, it's so much. But what are going to be the top 3 or 4 things that you would recommend?
Task force. You've got all the experts right there.
But let's hear your top 3 or 4, and then we will hear from the task force. And then we have public testimony that we will also take.
Well, I think that the most immediate impact for the protection of children would be to identify processes between juvenile court and civil custody court that would clarify the impact of a finding by DCFS. Because that's where I see things going off the rail, quite frankly.
Okay.
I also think that having a written protocol for DCFS investigations for specific to child sexual abuse, not only at the intake level but in the investigation phase, and also law enforcement, because again, as Deputy Sanji pointed out, there's some places that are operating well. If we could identify those that operate well with DCFS and the CACs and develop and implement those processes, particularly if they're written, it'd be easier to replicate. I think that would help with the initial investigation piece. And then I'm also, I think that it would be a good thing to address training. Not only in terms of the actual interviewing, but in terms of the impacts of child sexual abuse, the secondary or vicarious trauma for workers, the CACs, the law enforcement, because Lord knows law enforcement sees a lot of horrific things. I think that having clarity around the impact of the DCFS finding is critical. And I'm not sure that we don't, just as a society, invalid tends to connote it didn't happen. That's not what it means. And I'm not sure that that's well understood. So in terms of training, I think that's a big piece too.
And I will just add one other thing that I heard you say, that I would ask if the task force would see this as one of those prevalent issues as well, the multiple interviews. And I don't know if that would fall under.
That would be just general investigative protocols.
Okay. And with that said, in terms of recommendations, I am now going to turn to the task force to see if you agree. And so since we have you here, Judge Green, you are on a high spot, in a high seat, as it relates to the processes between juvenile court and civil court. Could you elaborate on that?
So I've wrote a number of notes. Is it working? Yeah.
Yes.
Good morning, everyone.
Thank you.
I am one of the judges that hears the cases that come to civil district court, or for purposes of, depending on the jurisdiction, it would be family court. East Baton Rouge Parish has our own family court, 4 judges that hear cases that may address child sexual abuse. We hear it in different ways. As Judge Ritchie indicated, it can come to us from a custody case. It can come to us as a regular custody case. It can come to us from emergency custody case, which is heard immediately, same day. Typically, that's where we get the allegation of child sexual abuse. And then it also can come through our domestic violence cases. In our domestic violence cases, if it's a familiar connection, then either it can be a sibling on sibling sexual abuse, where the mother or the father will ask for protection from a child in the home, which I've seen that, or from the parents, which Judge Ritchie has indicated has happened. And the problems that I think logic can't help is that there are timelines for us as well. Most family court cases want to move quickly. Not as quick as juvenile court, because there is no timeline. In juvenile court, the cases have 72-hour response times after the investigation has started. Family court, if you don't file an emergency custody case, our duty judges will get the temporary restraining order pleading that alleges sexual abuse in whatever form that parent chooses to allege that, and we will then put the protection in place for the next 2 weeks until they come to the hearing on domestic violence day. And so the problem with that is if it's just the allegation and they indicate a DCFS case or a CPS case has started, many times they have not had a interview immediately when they come to us on any of those days. We are literally taking the testimony, sometimes self-serving testimony, of the parent. And then there is one other opportunity for us to address it, is a request for a Watermeyer hearing, which is a child interview. And Watermeyer hearings in itself is the opportunity for the court to interview, but the case of Watermeyer hearings indicates that you can be the third party that hears it, or that you can send them to a medical provider, therapist, of some sort to address that. Again, no timeline is in place. And so what typically...
And this is outside of the DCFS and CAC process.
Yes, ma'am. And so...
Another layer of interviewing of a child.
So most family court judges will pause on having children come in and interview in Watermeyer hearings and allow for the third-party provider or the recommended therapist to hear, and we then take their recommendations. Again, that may take a minute, especially...
So when you say a minute, what do you mean in terms of the time frame by which you receive the information, or by the time frame by which you would actually have a hearing?
So the hearing itself can, again, depending on what they filed, can happen immediately. The issue is the investigation, from the medical provider, they have to get an appointment with the medical provider. Sometimes attorneys come in and request that the attorneys or pro se litigants, we have to recommend or suggest to them a list of providers. So that might not happen immediately if they didn't do the DCFS case or CPS investigation. The other part of DCFS is that they have 6 months to investigate. So most family court judges are saying, well, the investigation has started, but I can't necessarily subpoena them to come in court, DCFS. We try. Attorneys do try as well.
So 6 months by statute?
Yes, ma'am.
Okay.
And so the other thing, there is also law that provides that the judge can order, I do DCFS orders to the agency, and then the agency can immediately let me know if there is a pending investigation. So that can happen fairly quickly, and I'm saying fairly quickly. If it takes 30 days to get a hearing date, you get the hearing date, and then that's when I have the opportunity to put my order in place. I can order that DCFS responds. They can respond with the in-camera inspection, or providing they hand deliver the investigation packet that they have, which is what I do. But then they also can say, we're still investigating. All we can let you know is that it's pending. I can't tell you if it's valid or invalid. Again, that pushes my court case back. And in the interim, there may be protection needed in a restraining order form. There may be protection needed in a form of supervised custodial time, as well as limiting who could be the supervisor. There's a number of things that limits the custody judge. It doesn't mean that we are not there to help protect the children, but Judge Ritchie made a point that sometimes in family court, some of those allegations, we have to determine if they're credible, and if attorneys aren't willing to wait for those investigation reports to come back, they want to have a hearing. And
And let me interrupt for a minute, because I'm really dating myself now. I was on the Children's Code project in the 80s when the Children's Code was written. This jurisdictional issue was discussed, and the law says that juvenile court has exclusive original jurisdiction over any child in need of care matter, which means if there is a pending juvenile court case regarding child sexual abuse or any other abuse or neglect, then the idea is that any civil court custody proceedings would be suspended or pending an outcome of the SYNC case. That was the explanation at the time of the Children's Code project. That is not what is actually happening. So, although the law says exclusive original jurisdiction, that doesn't actually.
So why do you think?
Partly because during the investigative phase, there's nothing pending in court. There's not a SYNC case pending in court. Even though Title VI begins with an investigation, the jurisdiction issue may not be beginning until something is filed in juvenile court. And in places like Baton Rouge, family court and juvenile court communicate regularly, and so it's fairly easy to have judges aware of what's pending in the other court. That's not necessarily true in general jurisdiction courts because all the judges wear all the hats all the time. So, whether I'm sitting here as juvenile judge or I'm sitting here as family court judge, I'll decide. Does that make
That makes sense, and it makes sense. So I'm gonna go back to. Will you finish, Judge?
Yeah, I'm sorry.
Oh, no, you're fine. I think, so taking all that into consideration, going back to the recommendations, I think the first one is about clarity between the jurisdictions, right? And so I would venture to say that family court practitioners as well as judges tend to put their input in the Law Institute. They have a lot of conversations with that. They have a lot of concerns about the medical providers and how much information they provide. So you want the medical provider to immediately give you some reports. The attorneys are fighting against those reports, and they're coming to the Capitol with those interests in mind. And again, that would be hard at that for the civil district court. We do need clarity, but again, when you say it's like dual jurisdiction, and then I have to go through the children's code, then jump back to the family court laws, it does create some confusion. But again, most of these cases, I've given you all the ways that they can come, but if the allegations are coming through a protective order, the protection is probably going to come. But if you're waiting for a valid CPS or DCFS evidence report, then that might not come during that process because it's so quick that we come back to court. So I think training, I would support. Definitely clarity on findings. I find often that attorneys and even the pro se litigants that are trying to represent or may call you are those that are saying that I don't understand what you mean when you say it's invalid. They never called me or they didn't investigate. And in fact, when we get the report, they did investigate to some extent, but they found it to be invalid. And yes, that does change our custody that we order in family court if the initial letter comes back invalid.
Even though it's not that it didn't happen, it's that the evidence didn't support it.
And it takes a couple of more hearings for us
Some
to
judges
determine
will
it.
not even allow the custodial parent to present evidence because DCFS has decided it.
So I'm gonna go back to one of the questions that I did ask you, and I heard you mention it when you first started, Judge, when you say, logic is included, but as I listen, that there are some things for me that just that are not clear, and so hopefully, as we are beginning to outline this, we make it more logical, and maybe it can make sense to the person like me who is not a judge, who am very concerned when I hear about cases that are especially happening to those who really cannot communicate, and then they are being placed back in these situations where we know more 9 times out of 10 that more harm is being happening to them.
I do think that it's important to keep in mind that there have been false accusations, and it can really destroy a person's life to have the
I agree.
allegation. So I do think that there's some tension there, and my concern is the child. And
Mine's too.
even when there is a false allegation, in my view, something's wrong.
Something's wrong. That's right. Something's prompted.
May I say one thing?
Sure.
I think what the CACs, and I come from the child needed care background with a number of people that's on this panel, but I think the resources that you're indicating through your offices are definitely in place in juvenile court. We barely have numbers to contact all of those agencies, and so some of those resources may be needed to come to family court. Even some of the, maybe in trainings or some form of that nature, but I feel that some of the things that were stated, we actually don't do it. I am the case plan. I set the case plan up, as opposed to DCFS, after they determine that these allegations are valid, prepares a plan for the family. And I tell people that all the time, that the plan now comes from us, where in juvenile court, from us as the judges, juvenile court, the plan is presented to the judge. And so some of those resources may be the gap that we have in family court, especially with the time. And again, this is Baton Rouge. In New Orleans, your cases can happen within 60 days. That's a lot of time for an allegation to just be in the air. And so I think that you have to check the jurisdictions as well to see how quickly the hearings are happening in other parishes as well.
Well, and that's something that the law can address,
Yeah,
it's that
yes,
time limits.
yes,
But the other difference in resources as regarding children, in juvenile court, children are parties to the proceedings and therefore entitled to and provided lawyers. In civil custody court, that's not the case. The child does not have a voice in those proceedings.
So there's a lot that has been said just within the last couple of minutes hearing from the judge, which is a little alarming for me because you do have a background in this area, so it gives you, to me, more of the ability to be able to make those decisions based upon your background and experiences. But I don't know if all judges really have that. If they happen to write the plan, then what does that look like? Because that sounds like that's a level of continuity with what that looks like. I mean, it can vary from case to case, and I don't even know what they may use to actually even come up with the way of how they actually present or write up the plan, which is questionable too. Ms. Wascom, thank you, Judge. Are you finished?
I'm finished.
Okay, Ms. Wascom.
I have a question about the term invalid. Is that a legal term or is that a policy term? And I'm sorry?
Both?
Both.
It's in the law.
So I'm a writer. That's what I do. Specifically survivor-centered communication. And also as an adult survivor, like looking back 30, 40 years ago, on how that even...
How it's heard.
Well, it can shape a child to not disclose further abuse. And if that is something, just changing that word to, I'm not even sure, I'd have to think about it. But that, to me, seems like a very easy, like initial change, just for the children themselves, so that they feel like they are believed as a survivor. I think that is, I mean, as an adult now, I mean, my biggest thing is the systemic failures, and it's, I mean, everybody at this around here is going to hear, every one of us have heard, well, I wasn't believed, and I think that really can play into someone's psyche. So I just, if that's something, just that word alone that we could change. And I know it seems small, but if we're talking about a child and how the lasting impact, that would be one thing.
Dr. Wascom, I think that's a very good point. Words are very important. And when I heard the term, I was glad that someone really just kind of brought it back up in terms of invalid, because I'm thinking when I hear the word invalid, it means to me that it's dismissed. Yeah. And so I think that you really bring up a great issue, and we can think about what term that should be replaced with.
And come back with a list. I mean, that's like my thing. So, for sure.
Well, that would be a change in law and policy.
Yes.
And so if you're going to work on invalid, work on valid and inconclusive too.
Yeah. Well, and I'm just thinking about, I'm sorry. I'm just thinking about the language of changing from victim to survivor. You know, we never used that word 25 years ago, survivor, and just the kind of the light bulb moment that I can see for people that are currently struggling, like, and they're in the middle of a case, I have seen changes in a survivor feeling empowered versus feeling like a victim, because you don't feel like a victim, but when you're like, okay, if you can just individually, when you're telling someone you believe them, and it empowers them to say like, okay, now this is taking some ownership to be empowered.
One of the things I can do, because I think that there's a lot of information that the task force is going to need to consider before you start making specific recommendations, I can pull the law, and I'll give it to Ms. Peck and Ms. Trapp to be disseminated, the law where these words are used in the Children's Code. And I'm sure the agencies, who's has a lot of policy, they'll provide.
That'd be awesome.
Thank you.
And maybe law enforcement too, and the CACs. It kind of crosses the spectrum.
Thank you. And maybe that's something you can do for us for the next hearing.
Yeah, I'll get everything to Ms. Peck and Ms. Trapp.
Okay, great. Thank you. I don't see any more questions, but Mr. Thurberg, I would like to hear from you with your background as we discuss this and hear your perspective on any of these matters.
Okay. Well, my background started
Can you speak into the mic, please?
started as I was coerced to become an expert witness in the field, promised by the attorney.
That's a whole different area.
Promised by the attorney I would never appear in the courtroom. I appeared, and the result subsequently was over 300 cases. And one that I was thinking about, Idaho versus Wright, it actually went to the U.S. Supreme Court. And it had to do with in part, the competency of a 3-year-old child who made the allegations of sexual abuse against both mother and stepfather, as I recall. And the child was ruled incompetent, okay, as a witness, arbitrarily because of age 3. At the U.S. Supreme Court level, the issue was inability to confront the accuser. So one of the questions I was pondering here was, what are the criteria for competence of a witness, including a child who has been sexually abused?
Competence of witnesses is applicable to court proceedings. That doesn't mean that they're not competent to talk to law enforcement or to be interviewed by the CAC. And the forensic interview process, and maybe Ms. Hadley can explain more, or I know y'all have written protocols too, that everybody can review before your next meeting because we are running over here. There is a process to determine the child's level of understanding and ability before you even start asking the specific questions. But the level of competence required by the CAC or by DCFS or law enforcement is not the same as the level of competence required by a court. Judges are required to ensure admissible evidence and competency is part of that determination by a judge. And judges are, I'll use the word trained loosely. Judges do make those competence determinations regularly when children are called as witnesses. But what you're referring to is this competence determination is a court concept.
Yes.
There is a reduced standard when it's in a CAC or a DCFS office or in the child's own home. Sometimes with the same nurses also interview the child just to get the medical background they need to know what extent of an examination needs to be done. So children are questioned by a lot of folks in the process of determining if there's going to be a further investigation.
Right, thank you. Okay. So my research and the research I review for my position at LSU is I research memory processes in children By the way, the totality, the corpus of research on memory indicates that the average child at the age of 3 is able to report with accuracy, okay, events that have happened to them, including traumatic events. I think that's important to note because child witnesses have been the subject of a lot of vitriol in courtrooms because of incompetence. So we look over the 100 years of research in this area. Okay, so a child can be very competent in terms of memory processes. The problem is the delay between the event, okay, and when the evaluations begin. So a child can be very accurate at age 3, but they are also more subject to memory intrusions, more subject to suggestibility, okay? And this is one of the things that we research. And some of you may remember the McBarton cases back in the 1980s, okay, where children were subjected to interviewing that led to all kinds of suggestibility. And suggestibility is anything that can alter the storage of memories or the retrieval of memories or reporting of events. So very young children, they can be very accurate. They are also subject to suggestibility and having their memories overwritten by experiences. So the closer we have, the closer the gap between an event, okay, and the reporting of the event, so much the better. Our research also goes into lying behavior. Now, this is very fascinating to me. It's interesting that you have to have a certain mental age to evaluate whether or not what you say as an untruth will be acceptable to others. So I've been involved in a lot of false allegations, including lying behavior. But a child who lies effectively, and they have on the stand, has to have what is called theory of mind. That's an abstract term some of you have heard of. But it's the ability to understand the thinking and mindsets of other people. So if you're going to lie effectively, you've got to have an anticipation that what you say that is inaccurate will be acceptable to others. Children, by the way, at the age of 3, can lie in ways that cannot be effectively determined by their caregivers. So lying is another issue. And you and I were just talking about another important advent that came as a result of these cases where there was so much suggestibility. And that has to do with, it's called symbolic representation, okay? So in the good old days of the anatomical dolls, I thought that they no longer were used, but they are. I'm on the staff of the University of Minnesota. Therapists in Minnesota still use the anatomical dolls. The question is, when can a child understand that a doll or a drawing of a human figure represents their own body? Mm-hmm. And in our research, and research of a lot of other more important people, you can take an anatomical doll, show that to a child 3 to 7 years of age, typically, and you can touch the child, okay, on his shoulder or her shoulder and place a sticker where the touching occurred, and then you give the child a sticker to place on the doll. Can they do that effectively? And the answer is, with young children, no, they cannot do that effectively. Okay? It takes a certain mental age before the person can do that. So a lot of these early cases of court cases where there were, pardon me, where there were false allegations and suggestibility, the assumption made by the investigators was that any child will have this symbolic representation. They understand that a doll or a human figure drawing is a symbol of themselves. It takes quite a mental age, it's quite an advance when a child can do that. So line behavior, and we can go into that in some detail, the paradigms that have been used to investigate lying in children and when they can lie effectively, and the motivation to lie, that's important. Symbolic representation, and then areas of suggestibility. So all of this has ramifications to the investigations. We're also doing research on the kinds of questions asked to children that yield the most accurate information. Yeah, that's regardless of the time interval between an event and when it's investigated. Okay.
Thank you so much. That was very insightful. It's a lot to process, but that was really good. And I took a lot of notes and probably will circle back with you, especially as it relates to the level of questioning and what that should possibly look like and how often, or how can we streamline that process as it relates to how often they are being questioned.
That, by the way, I should have emphasized that. That's a key element. Repeated interviews. Okay.
Okay. I have not heard from you, Mr. Robertson. Would you like to add anything or say anything that you would like to say? Mr. Robertson? Not yet. Okay. And Ms. Brocksmith, I know that you may have asked a question, but is there anything that you would like to add or say? No. Okay. At this time, we do have at least 5 items here, and we can see whether or not we can address all of these, or if we're going to need to scale this back a little bit more. But I do believe that we may have public testimony at this time, and so we will actually allow for public testimony. Is there anybody from the public that would like to speak? Oh, okay. I thought we did. Okay, then. Well, we can begin to look at next steps. Next meeting, I would like to have by next month. Does Tuesdays work for everybody? Did this time work? No. Okay. Tell me what time works best. Hold on for a second.
I think the only suggestion was that the judges, both of us had court on Tuesdays.
Okay.
And so we did inform Ms. Trapp, so, and gave her our available dates. So any date outside of Tuesday is probably.
Oh, any day but Tuesday.
Yeah.
Okay. Okay. Anybody else? I would kind of not want to do Wednesdays. I'm sorry, not Wednesdays, Mondays, because they are just always so unpredictable. But Wednesday or Thursday would work. Does this time work? Okay. And on the ideas, and so I guess I would kind of go through these really quickly in terms of what I heard, and y'all can clarify or correct me if I'm not right. But the processes between juvenile and civil court, written protocols with DCFS intake and investigation, protocols and processes with law enforcement, clarity with training, and maybe this is the same thing, impacting the child and child abuse, and then the reporting process as it relates to the number of investigations with the victims. And then lastly, I guess I would add is the terminology of invalid, and then I think the judge added valid and inconclusive. Yes. Did I get that correct? Wow. Wow, okay. Judge, your light is pushed? Oh, okay. So, is there anything else? Would anybody else like to add anything else, Miss Russell? Did you want to add anything else?
No, I think.
Hold on for a second. There you go.
I'm glad that we're going to discuss procedures and maybe written procedures for DCFS. That, to me, would be very key. I handled sex abuse cases for 15 years, and I can tell you in those 15 years, I have no idea when DCFS would do certain things and why they did it. The number one thing that I was always frustrated with was, one, I didn't understand when they considered things valid, and when they would make decisions that were, for us, work against what we were trying to do. And I'll give you an example, and it's very recent because I'm handling a case now, is that when a child reports a father maybe had abused him or her, and they're placed with the paternal grandparents, and then we're starting to see pressure on the child at that point, and we have to come in and beg for them to find other placement, and by that time, sometimes the damage is done because we're not given placement from DCFS for our victims. We have to inquire about that. And so oftentimes it's not that they lied or they were canning, it's because they've been getting outside pressure from a grandparent or someone else. So written procedures that we as prosecutors could understand would definitely help our cases, as well as our advocacy centers, because our forensic interview as well has absolutely no idea the procedures and protocols in place with DCFS.
That is very good, and I'm so glad that you're sharing that, because I'm gonna need you guys to help me in terms of identifying like who should be actually, like which one of you is responsible or should be kind of bringing back this information for the next meeting. We know that the ombudsman's office is just a two-person show. Okay, Ms. Trapp, wait a minute. She's gonna help me out right here. Hold up.
Thank you. So in preparation for this first meeting, we did reach out to a few of the entities involved to start trying to gather some of this information. And so DCFS did respond, and we have received their protocols for centralized intake. We reached out to the District Attorneys Association to see if they had the multidisciplinary investigation team protocols, and they indicated that the LACAC would be, the CACs would be the group that would have that. So we reached out to the LACAC regarding that and the policies for forensic interview practices. We haven't heard anything back from them. If maybe Ms. Hadley could maybe. So we reached out to the LACAC. I don't know if we should reach out to the individual CACs.
With LACAC, I can get with Ms. Crystal, but we could provide our own individual one because it all varies just jurisdictionally. There's some differences among our protocols and what we adhere to and that others may do differently. We can provide our ones from the Gingerbread House, but then I can also connect with Crystal to get the LACAC if they have their concrete one.
I think that would be extremely helpful. So would you be responsible for doing that and bringing that information back? And then what were the other two that you mentioned so that we can assign someone to actually be responsible for that?
That would be two things.
Hold on. Let me put you back on.
It was MDT.
I'm sorry.
And the policies for forensic interview practices.
Okay.
And then the other request we had was through the Sheriff's Association. We were looking for the protocol for investigations of allegations of child sexual abuse for each jurisdiction.
Mrs. Sanjay, is that something that you'd be willing to take a look at and bring back for us to kind of see?
It's going to vary per jurisdiction as well. But I can get with them and find out.
At least what the standards are?
Yes.
Okay. And what was the first thing that you said at the very beginning?
With DCFS?
Yes.
We have received their information.
Okay, so we already have that.
We do have that. We can
Okay,
share that. We're
okay.
trying to gather all the information, but if for that next meeting, we'll go ahead and provide the DCFS policies and procedures that we've received.
So would you make sure that everybody receives a copy of that?
Yes, ma'am.
Okay. And so we'll have that information to discuss at the next hearing. Go ahead. Ms. Hook, is your button? Oh, I'm saying Dr. Hook, I'm sorry.
I just wanted to, before we close, make sure that we're mindful as a task force because the word evidence has come up a lot today. And just so that we're all clear and on the same page, that in the majority of cases, I would say the vast majority of cases for child sexual assault, there is not going to be physical evidence. So when we're making recommendations, we have to be mindful of that as a task force. Most exams are going to be, I don't want to use the word normal, but there are not going to be physical findings in the majority of cases where children are sexually assaulted or abused. And there are various reasons for that, but one of the reasons that is really important for us to remember is there's often delayed disclosure of the event. And when we're talking about the tissue in that area, it's basically like the inside of your mouth. So it's mucosal. And if you think about biting the inside of your mouth and then how quickly that heals and not seeing lasting injury from that, just keep that in mind when we're talking about physical evidence.
Thank you. That's very insightful as well. It's something that we do need to keep in mind while difficult to grasp. Yeah. I do want to acknowledge some of my colleagues that are here. I see Senator Beth Mizell. Thank you so much for just stopping in and listening. I see Representative Beryl Amade. Is that Beryl? No? I don't have on my glasses. I'm sorry. I thought that was her. Sorry. You're from DCFS. And so that's DCFS staff right here, along with the assistant. Good to see all of y'all. Is there anything that y'all wanted to add before we end or conclude? Come on. Oh, come on up.
Mona Chapman, DCFS. I was just going to add that we can also provide our template for law enforcement agreements that we did not send. So that is based on jurisdiction. It may be modified, but we use with our offices a standard template that our regions enter into agreements with the different jurisdictions on the investigative protocol. So we can provide that as well. We can also do research as related to the language used for valid, invalid. Sometimes we see states use substantiated and unsubstantiated, but we can do that research and provide that as well.
That would be really helpful. And I'm glad you brought up the law enforcement piece because I think I may have heard, I'm not quite sure who said it, about, it's different with each law enforcement office, and some is followed up on and some isn't.
Correct.
Do y'all have any stats or data that you can provide to us by, like, maybe parishes of reports with law enforcement where there may have been follow-up or no follow-up? Would y'all have that data?
Yeah, we don't have the data to provide on the law enforcement piece, but we do have data that there's some data that I sent already, and then we can also provide some additional data related to sexual abuse allegations and the validity percentages of what we find within DCFS broken down by the area. So we can provide additional data based on the conversations.
Okay, great. Thank you. I'm sorry.
If you could to provide an example.
Hold on, Ms. Shelton. Let me get you on. It's hard for me to press the button. Okay.
A copy of obviously not a real one, but an invalid versus valid letter, like the language that is in the letter that is sent to the alleged perpetrator that is often presented in family court so that everybody here could see what that letter looks like and what language is in it.
Okay, sounds good.
Thank you.
Thank you. Ms. Wascom? Did y'all have a question for Ms. Mona?
Just in general.
Okay.
It triggered I thought the language in the letter. Could we compare, if we had a glossary of terms, would the language be the same for the courts, DCFS, and law enforcement? Like if you're using a word valid or evidence, of course we're going to know what it generally means, but are the standards different for each person at this table? I think that would be one of my questions, because if you have a sheriff and their validity or inconclusive or evidence, they have a standard. So, and neither of y'all at the table realize that y'all have very different definitions. That could cause a breakdown as well.
Ms. Shelton, did I hear you say yes?
Yes.
Hold on.
The sheriff could provide an explanation of what they look for. Oh, sorry. In a criminal excavation, am I on? Okay. In a criminal investigation, and then the DA's office, what they would look for to charge someone, and then the difference in the language the DCFS uses for invalid versus valid. It is separate language, so if everybody would provide that, I think that would be helpful.
Okay.
I think I answered your question.
Yes, you did. And I'm writing this down. Ms. Wascom said that she would compile. Okay. Judge Green?
I think my contribution can be kind of have some cases. I will communicate with my colleagues, Family Court, and kind of do summations of cases in the last couple of years, maybe even a 5-year block, and what the judges have utilized as evidence and what, witnesses. And I'm just thinking of it in different ways, but my staff attorney will address how we compile it, but I'll bring something back to you guys.
Okay, great. Awesome.
From the district court level.
Okay, great. That sounds good. Well, it sounds like we have gotten to the final conclusion of today's meeting, unless someone would like to add anything else. Certainly, I do want to thank everyone for being here today. This is a very important subject matter, and my colleague out there, Senator Beth Mizell, she and I have talked about this issue along with several other issues as it relates to matters affecting children, looking at the gaps to try to make sure that we are bridging those and making sure that we are providing the best path forward for our children. I do want to thank the staff again for doing such an amazing job and helping us to pull all of this together. And I am looking at the second week in November after the elections. Hallelujah. I'll be glad when it's over. The week of November 11th through the 15th, and possibly either the 13th or the 14th. Is there a preference? Ms. Russell?
The 14th, I have a Human Sex Trafficking Commission and Board meeting that morning, so the Wednesday would be clear.
Okay. Wednesday looks best for me, too. Sound like that's a majority. Okay, so our next meeting would be November 13th at 10 a.m. And there are assignments that have been given out to everyone. I'm going to get with staff to make sure I have all that clear. And so when we come back, we are going to be expecting that individuals will come with information to provide to us as it relates to recommendations or suggestions or just mere discussion of what we've talked about today, the impact of that, and how we could possibly move forward with it, or at least continue to investigate and look into that particular issue. The thing that I do need to say is I know that we are right around the holidays, and so we will not meet in December, but we will meet back in January. We are scheduled to actually provide a report in January, but we're going to be at least a month late. We're going to submit it in February because session starts in April, and I would like to come back with maybe perhaps an omnibus bill that may have several different pieces, because it's going to be a fiscal session, which means we are limited to the number of bills that we can file that are not fiscal. But my colleague is out there, so if I can't do it, I know that she'd be more than happy to take it up, but we are limited to the number of non-fiscal bills we can actually file. And so I do want to come back with something. And my goal would be, because I know that we are not going to be able to address all of this in 1 year, is to continue this task force going forward for next year for some of the things, some of the other issues that came up today that we just cannot cover. And I'm thinking that law enforcement needs to be a part of this task force. So that's one of the things I'm going to say. And it was another group that Voice for the Child. And so that certainly needs to be a part of the conversation. They need to be at the table. And we're going to officially add Fathers on a Mission because based on our conversation as it relates to falsely being accused and things of that sort, I think we need to make sure that those individuals are also always represented. So with that said, I am not going to belabor the issue. We have done a great job at getting you guys out before noon. Everybody can go and grab them some lunch. Again, thank you so very much, and we will see you guys next month on November 13th at 10 a.m. Thank you.